Recorded live for us at the Presidential Election Petition Court, where the 5 justices of the Court of Appeal unanimously, just a few minutes earlier today, indeed affirmed the declaration of Bola Ahmed Tinubu as President of Nigeria, and also dismissing the petition filed by the APM, Labour Party, and the People's Democratic Party for lacking merit and failure of petitioners to prove all allegations. I'm joined now by constitutional lawyer and senior advocate of Nigeria, Wahab Shittu. Senior advocate, thank you for staying the course.
Thank you.
It's been a grueling 12-hour session, and I know that you have monitored election petition tribunals for years now. This particular proceeding was televised live. Is it unprecedented, the length of time, or is it a norm for a presidential petition like this?
Well, I think in the history of this country, what has happened today is really, really unprecedented. Not only has this judgment taken the length of time unprecedented in history, it is also the first time this kind of judgment will be televised worldwide, for the benefit of local and international audience. I think all stakeholders in the administration of justice should feel very proud of what our judiciary has shown today. All Nigerians should feel very proud. All lovers of democracy should also feel very proud. My own perspective is that we have shown clearly to the world that our democracy is working. We have also shown that central to our democracy is our respect for the rule of law. For me, there are no victors, there are no vanquished. For me, all those who have participated in the process are winners, because ultimately the president who has emerged from this process is the president of the entire country, and is superintends over all institutions, all authorities, all political parties, all opponents. They will now come under his own umbrella as the father of the nation. So I think the way to go is not to malign, abuse, or scorn anybody as losers. I think the way to go is for us to see what has happened today as a collective victory. And I think what we should also see clearly displayed today is that we have seen how the judiciary works.
It also would seem that the judiciary had a point to prove, saying how detailed the justices went in reeling out all of the judgments that we saw in the past 12 hours. But what's your thoughts of the judgment per se? Are you surprised by the outcome?
Well, I'm not altogether surprised at the outcome, because I know that judgments, I know how the judiciary functions. A lot of people who make commentaries in the public space do not know how the judiciary works, or perhaps they do not take time to find out the workings of the judiciary. And this is what has been shown today. The judiciary works on the basis of facts. The judiciary also works on the basis of evidence. The judiciary works on the basis of proof. The judiciary works on the basis of findings. The judiciary works on the basis of settled legal principles. And then the judiciary also works on the basis of conclusions arising from those settled legal principles. You can see that the judges are detached. The judges have shown courage. They have shown deep knowledge of our jurisprudence. You see, if, for instance, and at this level, this is the level where this is the Court of Appeal in presidential election is like the court of first instance, where evidence is taken, where documents are admitted, where witnesses are called and give evidence. So and this is the stage where evidence is evaluated. Because the justices take evidence from witnesses and all that. When the matter moves from this stage, evidence is not taken. If the matter moves from this stage to the Supreme Court, witnesses are not called. documents are not tendered at the Supreme Court. What the Supreme Court will look at is the record of proceedings from the Court of Appeal. So, and they will see whether, arising from the record of proceedings from the Court of Appeal, whether documents were properly admitted, whether evidence was properly taken, and whether conclusions were properly reached, arising from legal principles. I'm so happy. I celebrate the judiciary because before now, attempts were being made to rubbish our judiciary, to malign our judiciary, to scandalize our judiciary unfairly. And if we succeed, if we had succeeded, if the detractors had succeeded, that would have been an end to democracy. Because central to the democratic tradition is the judiciary, is respect for the judiciary. If we don't respect the judiciary, anarchy looms. So I'm very happy today that the judiciary has risen to the occasion to show that we are men and women of sterling integrity. We are unbiased umpires. We deploy the law to the facts and evidence as presented.
Well, that's how you see it as a senior advocate.
Yes.
There are varied reactions to what we've seen in the past hours. For instance, the Labour Party has already rejected the judgment, saying that it will decide its next step after consulting with lawyers. But let's talk about how unique the unanimous decision is for a case of this stature, and how much credence this has brought to today's verdict, the fact that all of the 5 justices seem to have seen it the same way.
When you have a unanimous decisions, such as you have had, it means that judges, all the justices who saw witnesses testify, who saw evidence laid, who saw documents tendered, who appreciated, who applied the law, saw all of this in the same way. They agreed unanimously with the conclusion reached. This is a unanimous decision. It is not just in terms. All of them agreed unanimously on the preliminary applications. There was no dissent. They also agreed unanimously on the merits of the case at this stage of the proceedings. So the fact that it's a unanimous decision at this stage of the proceedings makes it watertight at this stage of the proceedings. But I will tell you that this is like the semi-final stage of the proceedings. The final stage of the proceedings is the Supreme Court. You said the lawyers said they are going to decide their own line of action.
No, the party said it will meet with...
yes. I hope that whatever the parties then decide to do will be a decision on the part of constitutionalism.
Indeed.
A decision on the part of respect for the rule of law. And what is that decision? That decision that follows constitutional approaches and rule of law approach will be a decision we say, oh, we want to appeal, or we decide not to appeal, not a decision that...
Hold on for a minute, senior advocate. Let's bring in another lawyer on this conversation. Olayinka Daniels joins us live via Zoom. Mr. Daniels, thank you for joining us on the news this hour. The Court of Appeal made some landmark decisions on very critical issues in the preceding hours, particularly about some issues that have been raised in the past 6 months following the 2023 election. I want to hear your thought about the dismissal of the 25% votes required for a president to emerge in the FCT. The Court of Appeal is saying Abuja is like every other state with no special status. How satisfactory for you is this court's interpretation of Section 132 of the Constitution?
Well, I would say that from time before now, some of us, we have said that the people, they were clamoring for some interpretation of that particular section. They're just being mischievous, in a way, because it's clear, and we have said it, that FCT does not have a particular special status. It's just one of them, and it's so clear in the Constitution when it said "and." So you can have 25% in FCT. You do not need to have 25% in FCT to win the election. It's clear, ab initio. So people that are clamoring on it, they're just looking for a way. When you don't have a case and you just want to put all sorts that you think you can use to manipulate the people. I think that is that is actually as a result of some of the issues brought.
Right.
Looking at 25% as one of an issue to to cancel the election.
I hear you, Mr.
We
Daniels.
all know that is just.
Let me hear the senior advocate's thought on this. Will this decision by the Court of Appeal lay that issue to rest in future election disputes? Because I hear you say there is still the Supreme Court that can...
Well, as far as the law is concerned, today, the law is as pronounced by the justices of the Court of Appeal today, until the contrary. And so I'm happy that this controversy, as at this stage, is settled. I'm more particularly happy for our president, President Bola Ahmed Tinubu. This judgment has, like Pontius Pilate, washed him clean. The justices of the Court of Appeal have given him a clean bill of health, that he is not a criminal, that he is not a drug addict, that he has not been convicted before, that he has not been arraigned for any offense, he has not been indicted. So, lovers of democracy, lovers of this country, should now hold their heads high, that we have a president who is above board, who is credible, who is integrity driven, who is integrity personified, and who can lead the most popular black country in Africa, the largest black country in Africa. Because before this judgment, some of us are worried that our president and the chairman of ECOWAS, somebody who's leading the largest, most populous black African nation, is being tarred with this kind of stigma. Today, what the Court of Appeal has done is to wash our president very clean.
All right.
And we now know that we can all now rally around him and ensure that he succeeds in his assignment.
Mr. Ola Daniels, the court today also ruled that INEC is not mandated to electronically transmit or transfer election results, and that glitches experienced during the February presidential election wasn't employed to manipulate results. As a matter of fact, it says the petitioners couldn't prove, without reasonable doubt that it was a manipulation plot. But let's talk about the impact that the Electoral Act of 2022 has had on the Court of Appeal's verdict today, and whether or not you think it's an improvement on what we've had in the past.
Yeah, we must understand that the court is not a Father Christmas, and will not give you what does not exist or what you have not asked for. And looking at the Electoral Act, it's clear. And we have said this also before the court even made his own judgment on it. That look, the Electoral Act is clear. The uploading, the rev, as the Electoral Act does not give any room for it. There is no law under the Electoral Act that says that must be done. It is a guideline. There's difference between guideline rules and the law. Law is different from it. So a lot of people, like I said, when you are just being mischievous, you know the truth. And that is why it's so sad that today the Court of Appeal had to teach a lot of people a lot of lessons. The Court of Appeal had to lecture a lot of lawyers because we know the truth. The Electoral Act is clear on this, and the improvement that has done, thankfully, well, maybe in future, we may need to consider that, but then we may need to go back to the legislative arms of government to see how the law can be repealed to fit in those provisions if we want to make them part of the law that exists and that guide the entire election. But as this last election, what INEC did is not out of place. If you have plan A, you must have plan B. And if it is not the law, if it is the regulations, if it is guidelines, anything can happen. An hiccup can happen, and you cannot then use that particular itch to then say you want that the election is not worthy, the election is not free, the election is not fair, just because a particular guideline wasn't used for that particular election. The question is, has any law been breached? Has any law been violated? No. And the Court of Appeal made it clear in his judgment. He said, we are not supposed to wait till the time court will be telling us the right thing. We know it. And I just hope that lawyers, both our seniors and lawyers should know the truth and they should uphold it. And we should not just because we need to, probably for one reason or the other, for different motives, we just want to waste the time of the court. We want to waste the time of Nigerians. We just want to create chaos where there is none. For me, the Electoral Act has really made an improvement, and we all know, we can see what Beavers did. Thankfully,